7:30. Great.
Okay, we're gonna call to order our 7:30 hearing of the Milton Board of Appeals. Today is October 1st, 2009, 7:30 in the John Cronin Conference Room. This is upon the application of Kerry and Michael Norris, dated August 5, 2019, on file with the board for a special permit pursuant to Section 3A9 of the Milton zoning bylaw, so as to permit the temporary in-law apartment of John and Helena Norris within the existing dwelling located at 14 Lyman Road in accordance with a special permit originally granted by the board on December 9, 2010, and extended to December 9, 2018 in November of 2014. Section 3A9 of the bylaw permits temporary in-law apartments within single-family dwellings for a period of 4 years, subject to the issuance of the special permit, which may be extended by the board. All is set forth in the application and on file with the board. My name is Jeffrey Mullen. I'll be acting as the chair of the Board of Appeals tonight. With me on my right is Emmanuel Alves, and on my left is Virginia Donahue King. I have the application. I have the notice that appeared in the newspaper advertising this hearing. I've got a note indicating that this special permit was originally issued on December 9, 2010, and extended in 2014 so that it expires on December 9, 2018. I've got a list of abutters, abutters report. And I have a note here from Anna Marie McAuliffe of 5 Mather Street indicating that she's got no objections. That's the extent of the file. Mr. and Mrs. Norris, welcome to the Board of Appeals. Why don't you all come up? Welcome to the Board of Appeals. How can we help you?
Nothing, we're just...
Why don't you have a seat, tell us who you are, where you live, and what we can do for you.
14 Lyman Road, Milton. We bought my grandfather's house. We lived there. He built it between 1953 and 1956. I'm my father's father. My parents sold their house. They lived with us half the year, and that's the sole reason for the in-law apartment, and they continue to. It's not for rental, and we understand that were we to attempt to rent it to someone, that we would have to take it down.
So who lives in the house?
Me, my wife, my 2 children who are away at college this year, but
You're the,
yes.
you're the wife.
I'm the wife.
These are your in-laws?
He's my in-law.
Okay. And when did you buy the property?
2004.
2004. So you were the original applicant in 2010?
Yes.
And have you always been the occupants of it under the temporary arrangement?
Yes.
Yes.
So since 2010, you've lived there temporarily?
Yes.
Can I ask you if any other situation with respect to the use or ownership of the property has changed since 2014?
No.
Nothing.
Okay. Do you have anything else you'd like to share with us?
Nope.
Have you talked to your abutters about this?
The ones who've come
Just the
in
ones we've
contact
seen.
with.
We have 2 brand-new owners, well, 3 brand-new owners around us, so
So we have,
we just assumed.
One at a time, one at a time. So, go ahead.
Okay. I just remember, too, where's the 3rd house that sold?
The house beside the corner house.
Oh, yes, the Stefano's house.
Right.
Okay.
this
Well, yeah, I lived there once as a little kid.
Go ahead.
we don't know our new neighbors very well yet.
Okay.
And one of the neighbors that Mr. Bell was very happy that lives on Pleasant Street.
Where does Anna Marie McAuliffe live?
She must be behind us on the
She's on
She's on Mathos? Just the
She's
next
just direct
street
about
over.
behind you?
No, she might be to the right of us.
Okay.
So right to our house.
Okay, let me ask my colleagues if they've got any questions of the applicant or the occupants of the temporary apartment.
Well, I'm satisfied that nothing's changed, and so I think we should be good to go.
Manny?
No, but I would note that this actually expired in December, so
Yes.
so
didn't realize
there was I think there was a lot on the file, so be careful.
So I understand from talking to Joe and Jay that now that
Computers
you're on board and all the material is computerized, that
will be coming out.
it won't go the 5 years that it did this past time, I would think.
Oh,
Because it was supposed to be up to
18? Not 5 years?
2004.
Okay.
Yes, but this is
December.
19.
I have no other questions.
Okay, so the matter is a 4-year extension. The matter being asked for is a 4-year extension. Manny, would you say it's a 4-year extension from December 9, 2018, or from the date of the application, or from the date of the issuance?
It's a good question. I think they keep the record consistent to show that there was no gap in the issuance of this permit. We should link it back to the date it was. So December of 18.
All right, so the board is considering the extension of the permit effective as of the date that it expired, which is December 9, 2018. That means should it be granted, it will expire in 2022.
Now, sorry.
Yes, sir.
Now, is the onus on us in 4 years'
Yes,
time
sir.
to reapply, or will we be notified?
You should not assume you will be notified. You should put a big post-it note.
Okay.
How
You
long,
should first get the extension, and then you should worry about how to further extend.
Exactly.
no, that's 2020.
I'm sorry,
How long in advance before the expiration date should we apply?
Ms. Sutton, what would you say?
6 months?
6 months? Okay.
Okay.
Just in case we are backlogged.
So let me ask if there's anybody in the audience who'd like to be heard in support of this application. Let me ask if there's anybody who'd like to be heard in opposition or has a question about the application. Hearing none in both cases. Unless there's more questions from my members of the board or from the applicants, we're going to close the evidentiary portion of the hearing and debate the merits of the application in accordance with the open meeting law. Okay, so moved. Mrs. King.
Well, it's been working well for this family since 2010, and nothing has changed. And other than this little lapse, there's no complaints about it, and we're hardly complaining about it. So I am very much inclined to vote in favor of the application.
I agree.
Mr. Alves.
I agree.
I agree as well. I think it's a reasonable thing. It actually has the effect of saving another unit, which is a good thing for the town, and I think should be encouraged. I think the bylaw's getting a little bit out of date, but that's not an issue we can address right now. But I too will vote to support the extension of the temporary apartment at 14 Lyman Road for an additional 4-year period effective as of December 9, 2018. All in favor?
Aye.
So moved. So the permit's been extended. The board will issue a decision. We'll provide that to you. You should take that, record that at the registry in Dedham, Norfolk County Registry of Deeds in Dedham, and you'll have that for additional 3 years and a couple of months.
Right.
And we wish you good luck with your property and your stay in Florida. Okay, good luck. Thank you. You can work with Ms. Sutton, too. We work the paperwork, yeah. To do the paperwork, okay? Okay, Jenny, thank you. Thank you, good luck to you. You're welcome.
Good luck.
Beth, could you write down how long that hearing took and let John Leonard know when he gets back? Okay?
I think we could have
No
done
frolic, no detour, no talk about insurance.
it. We could have done it in less time.
If you were the chair, I can name that tune.
I know you can. That's why I wanted to point that out, just so that you could say that.
You're dating yourself.
I see the applicant for the next hearing is here, but that doesn't start till 7:45, okay? So we'll just hang on a
So
second.
we could have actually taken 5 more
Did you let
minutes.
John know that as well?
Duly noted.
'Cause I'm only acting chair. He's the real chair, and he's going to want to know. Full report.
Nothing Like healthy competition.
I'll let him know.
Why don't we keep that with that?
This is the,
It's the original.
Yeah, that's 2010.
oh, the
Who's
original.
writing?
For the,
Who's taking this one?
oh,
Ginny.
c'est moi. Moi. This is the two, right? Three, what was the third?
I sent you twice. Missing.
Okay, what are we looking at here?
This is another temporary apartment.
Oh, right, okay, never mind.
Easy to get mixed up.
Well, I got two on the horizon here, so, yeah.
You do, actually, you really, yeah.
I feel
really appreciate
I
that.
had to make up for my absence during my disability.
No, you didn't, but I really appreciate it. And I actually have to go had to go late into the mid-November because I'm going to be away for 10 days, so.
Someplace exciting?
Oh, yes,
Good, where?
somewhere warm.
Caribbean?
Fripp Island for 4 days.
Which island?
Fripp.
Fripp.
It's St. Helena. It's off the coast of South Carolina.
Oh, okay, okay.
Wow.
It's all in.
Never heard of it. Fripp, F-R-I-P-P?
It's past Paris Island, Paris.
Yeah.
So past that, it's near Beaufort. Because we drive off the island and go into
Is
Beaufort.
that how they pronounce it down there? They pronounce it Buford?
What about Beaufort? Something there.
The evening. This is upon the application of Joseph and Laura Wood dated July 30, 2019, on file with the boards for a special permit and variances from the terms of the zoning bylaw. The applicants propose to build a 22 by 32 by one story addition to the rear of the home, and within this addition at 539 Allerton Street, an 800 square foot temporary apartment will be included. The existing home was built in approximately 1985 and currently conforms to the bylaws with respect to use and dimension. The property lies in a Residence A zoning district. The bylaw, Section A9, detached one-family dwelling with temporary apartment, permits the creation of a complete and separate dwelling unit within a single-family home upon the issuance of a special permit by the board for a period of not more than 4 years and subject to certain prescribed conditions. Subsection A3A9 prescribes the temporary apartment be located entirely within this structure. All is set forth in the application on file with the board. I have in front of me the application requesting the special permit. I also have a letter from the building commissioner to Attorney Marion McKettrick, a proposed addition plan for 539 Allerton dated June 20, 2019.
Atherton, sorry.
539 Atherton, and I've got plans of the improvements that were also submitted, renovations and additions to Wood Residence, 539 Atherton Street, Milton, submitted by Timeless Architecture, all of which is in the file. I've also got a deed of the premises from Kenneth Johnson and Tracy Johnson to Joseph C. Wood and Laura A. Wood, and dated 2019. I see the applicant. My name is Jeffrey Mullen. I'll be acting as the chair. With me to my right is Emmanuel Alves, and to my left is Virginia Donahue King, members of the board. I see Mrs. McKettrick is here with the applicant. Welcome to the Board of Appeals. How can we help you?
Good evening.
Good evening.
Good evening.
Well, we're here tonight with an application for a temporary apartment, similar to the one you just did, except that this is a new one. This is an application, though, to place the temporary apartment in an addition that is being constructed now. It has a building permit, and if you grant the relief we request tonight, the temporary apartment could be constructed at the same time that the addition is completed. In order to do that, though, we have to apply not only for a special permit under Section 3 of the bylaw, we also have to apply for a variance, because the bylaw requires that a temporary apartment be created in an existing house or existing structure, and this structure is being added on to. It's not completed. The addition isn't completed yet, so we can't treat it as an existing house as it will be when it's completed. So I haven't given you a letter, and there's a description in the letter, but I guess I'll just, address some of the main points. This is a one-story addition. It's located in back of the garage, and this house is a very attractive sort of colonial-style house with a wide front with an attached garage on the left side. The addition is behind the garage, and it's one story, so it's not going to be particularly visible to anyone once it's completed. It's nicely designed. It will contain 787 square feet. It's an architect-designed addition. And if a temporary apartment is permitted to be located there, the temporary apartment would have a kitchen living area, one bedroom, and one bathroom. And the tenant will be the mother, Mary Louise Wood. And
I'm sorry, whose mother?
Whose mother?
My husband's mother, Joseph's.
Mr. Woods. Sorry. I didn't know whether you wanted me to say your mother-in-law or exactly how you want to.
Well, it matters the way the bylaw is written. You just have to know who these people are.
Yes,
so.
yes. So it's Mr. Wood's mother. When the temporary apartment is no longer used for this purpose, it would then be changed back into an exercise room and game room, and the kitchen would be removed. And you have plans for both the proposed apartment and the area if it were to be reincorporated as part of the house. At the rear of this house is a wooded area. To the right in the backyard is still most of the backyard, so the design preserves most of the outdoor living space for the house. And there is a nice porch sort of wrapping around the addition that will be accessible by the main house as well as the addition. So it's not really just part of the addition, it's part of the whole structure. The addition is entered the same way the house can be entered, from a mudroom on the left-hand side between the garage and the rest of the house. The apartment won't change the appearance of the house from the front. We spent quite a bit of time with the architect looking at alternative designs. I came to a couple of those meetings. We looked at addition above the garage, addition to the left of the garage, but in the end, this design was chosen because, well, it leaves a good part of the backyard still available. It's not very visible, and it just seemed to be, the least intrusive, but the best designed. And all the thing is, an addition above the garage is not ideal for somebody who's growing older, because you'd have to go upstairs to get to it or put in an elevator. The applicants have 3 children who live in the house with them, and their architect's name is Henry McLean. They are aware that there's a requirement that they have to return to the Board of Appeals before a 4-year permit expires in order to apply for an extension of the permit if they're continuing to use the addition. And they're also aware that if they did discontinue this use, that they would have to immediately convert the addition back to a game room or an exercise room, as I've described. So I was going to ask Laura to just mention any conversation she's had. You can come sit up here if you like. Did you have contact with neighbors, and what kind of feedback have you had?
Yeah, good question. So we just moved in May, so we're just meeting our neighbors. But we have spoken directly to 2 of our neighbors who are in support, and then a third neighbor who I've mentioned it to, but we haven't been able to catch again because his schedule doesn't work with ours, to just talk, specifically about it. But we had mentioned it to him when we met him.
Is this property between Blue Hill Avenue and Canton Avenue?
Yeah? Yes.
And is it on the right as you're going towards Canton Avenue?
Yeah.
Okay.
I'm sorry, I just moved in May, so I'm not totally familiar with everything.
I know the house. Okay, I just wanted to make sure I had the right house in my mind. Okay. No, go ahead.
Did you get the neighbors' names? The ones.
I don't. Okay, so on the right are I think McDonoughs. I spoke to him and his son, an older gentleman and his son, who live there alone. And then across the street from us is Connie. I don't have her last name on me. I apologize, but we talk to Connie all the time. And Connie is fine. And then our neighbors to the left are the ones who I've only met once, and I spoke with very briefly. Have not had an opportunity to catch him again. And I don't know his last name. I apologize.
Okay. Do you have anything else?
Nope, that's my summary.
Let me ask you a couple of questions. Tell me the name of the person who'll be living in the temporary apartment.
Mary Lou Wood.
Mary Lou Wood. Is Mary Lou Wood here right now?
No, she's watching my children.
Mary Lou Wood is watching your children. And she is your mother-in-law, so she's your husband's mother?
Correct.
Okay. And where does she live now?
Canton.
And so she'll be moving to this premise, this property?
Correct.
She'll be the only person living there?
Correct.
Okay. And was the idea when you first were designing the building that you weren't going to do this, and that what prompted this is a last-minute change, or why is it that you have the alternative design and the idea to construct this? Why you started construction without this relief? What was this? Is this a last-minute change, or is this the way you always planned it?
I believe this is how the building...
This is how it was planned.
Okay.
But you can't legally simultaneously create the in-law.
So it was only it was last-minute realization that you had this little hiccup that you...
Well, when we met with the building commissioner, he said, in this case, because of the way the addition is designed, it could legitimately be just an addition to the house. He decided he would allow a building permit to be filed for the addition, but that if you wanted to apply at the same time to create the in-law apartment, we needed to come to the Board of Appeals for relief for that. So at least from my perspective, the addition being created and the in-law apartment being part of it were simultaneous discussions, but I don't know how long you've been considering what to do, so.
Well, I like the fact that you've got drawings, because it does show that in the event that the permit lapses or if something else happens, you've got these plans. And what I heard, I'll just confirm your representation, that in the event that that does happen, that if something happens to either invalidate the permit, or it lapses, or some other circumstances under the bylaw happen, the property will be converted as shown on the drawings, not otherwise. Okay.
That's correct.
Okay. Let's see. And the property is said to be 800 square feet. The temporary apartment is 800 feet, but you said 787.
Yeah, I think at one point in my letter, I say 800, but it's actually, it's close to 800.
You know what, I don't think we have your letter. At least it's not in the file. It's not in my file.
Oh, okay, there you go.
So maybe you could just leave that with us?
I certainly will.
Okay.
I don't know how that happened. There you go. There's one copy.
And what's the status of the construction right now?
They just poured the foundation.
Okay. And is your thinking that by doing it this way, you'll save some money? You'll save some, be efficient? What's your overall thinking on not building it and not putting the temporary apartment in and coming back later? Is there some efficiency built in there?
I'm not clear of the question. Sorry.
Why do you want to do it this way as opposed to the way that it's requested under the bylaw? It's permitted under the bylaw.
I don't know. I believe I was told this is the way I had to do it.
Okay.
Well, and
There is a certain amount of efficiency in doing it this way.
yeah, the answer in general with applications like this, and what we had discussed, was the idea that building commissioner will not allow the plumbing connections and the pipes that will need to go in for the kitchen for the temporary apartment in the addition, unless you have an approval for the apartment, because that's not a component of the addition as part of the house. He has complete detailed building plans. They could go ahead if you didn't approve this with building their addition, but they would not be able to put in that component. So if we waited until the addition were finished, then an application could be filed. We'd have to get the special permit from you. And we couldn't do it until the addition was finished because it's supposed to be built in a completed house. And then they would have to open the wall up, install the pipes. There's a new wall that would have just been put in. So that's the inefficiency of trying to do it afterwards. The building commissioner does not always determine that you can commence construction on an addition, depending on how it's designed. There are instances that I've experienced where he said, no, you must go to the Board of Appeals first, then I'll let you start, but you need permission for everything. It depends on the way it's designed, how the architects designed it, and how it integrates with the house.
Okay.
Sometimes in these cases, it's also a question of time. You know, how quickly you want your mother-in-law to be able to move into the house.
Mother-in-law have a car?
Yes.
If she's helping with babysitting and so on and so forth, it's certainly something that the family looks forward to.
Your mother-in-law be there 12 months a year?
Yes.
Any other questions by members of the board, the applicant or the applicant's counsel? Ginny?
No, I don't.
Manny?
This is probably hyper-technical, but there's two provisions in here that I think would need to vary. One talks about the temporary apartment being contained within the structure. The second talks about the designs submitted with the application showing that there are no exterior changes being done to the existing dwelling. They get to the same point, but technically, if you look at subsection D, I think that's implicated as well.
That's right.
So 3A9 and what was the second section? What's the
D and F is the one that says it must be contained within the existing structure, but before F in D, when it talks about the types of designs you need to submit for the application, it says that designs must show that there's no exterior modifications to the dwelling, which obviously that's...
So I agree with you that technically both should be varied.
Yeah.
And that's a good.
I mean, it gets to the same point, right? I mean,
So is it 3A9D and 3A9F?
I believe so, yeah.
Okay.
Okay, we'll note that for the record.
Request is to vary, then accordingly, we would request to vary those two sections to allow simultaneous construction. temporary in addition.
Other questions?
I don't.
Now, let me just confirm, the apartment is going to be a gathering room, a kitchen, a bedroom, a bath, with an entry off of the mudroom. Is there an entry from the apartment into the main room, main house?
Well, the mudroom is between the, no, well, correct me if I'm wrong, but the mudroom is between the main house and the garage.
Correct.
So the entrance to the apartment in the mudroom is part of the main house, is through the mudroom. So you enter from the front, you go into the mudroom, you go out the mudroom, and then you enter the apartment in the back.
You have
and
to
the
go back
porch is
into the
on
mudroom to go into the house.
That's correct.
Correct.
There's no other way to get to the house from the apartment.
No.
Correct.
And if the apartment, at the end of 4 years, if it's not extended or if it otherwise lapses, it will be converted into an exercise room. The bedroom will stay, there'll be a game room, but otherwise it'll really be the same space. The kitchen will come out.
Correct.
Okay. I don't have any further questions. Anybody else have questions? Can I ask if there's anybody in the audience who'd like to speak in support of this application? Is anybody who'd like to speak in opposition to the application? Hearing none in both cases, we'll close the evidentiary portion of the hearing and hear evidence on the application in accordance with the open meeting law. Mr. Alves.
I thank you for the presentation, Mrs. McKettrick. I think this makes sense. I think this is a bylaw that's probably crying for amendment. But the outcome here, if we don't go down this route, would be for you to build it and then come in afterwards for a second hearing to get a variance before the apartment gets occupied. I think doing it once and requesting both sets of relief makes a lot of sense. I think based on what I've heard, the requirements of 3A9 are met, except for the need to vary subsections D and F. So no objections. I'd be inclined to vote in favor of the application.
Mrs. King.
As would I. I like the DNF way that you've presented that as being needed to be varied, and I think that this is a smoother way of doing it for the town as well as you. So I'm in favor.
I agree. I don't have anything to add from my colleagues. I support the application. All in favor?
Aye.
So moved. Congratulations. We'll work with Beverly and Ms. Sutton on preparing the written decision a few weeks' time and be on your way. And Mrs. McKettrick certainly knows the procedure. Thank you very much. Good luck.
Congratulations.
Thank you.
Oh, good job.
Okay, man, thanks. You have that original permit.
Is the letter in there?
It's,
Annie,
yeah.
Did everybody not receive the letter, or was
wasn't in the file. It's okay.
it strange? I've never.
Is it in that?
Apologize. It was in my file. I don't know why I didn't get it in yours. Anyway, it's now in the record, and I've given it.
Yeah, thank you.
Thank you. Is it in here, or?
We're going to call to order our, is what?
Nope, keep going.
Call to order our third hearing tonight upon the application of Haydar Ali,
This is
dated August 2, on file with the board for an
This was an
amendment
extra.
of a December 7, 1955 special permit seeking display of advertising signs at 131 Brook Road. According to the condition of a special permit issued by the Board of Appeals on December 7, 1955, under the terms of Section 4 of Chapter 10 of the bylaws, the zoning bylaw, advertising signs on the premises require a permit from the board. The use of the premises for vehicle repairs is a pre-existing non-conforming use. The 1955 special permit allowed construction of a new garage for the vehicle repair business subject to certain specific conditions. The applicant requests approval to display the following advertising signs: one movable state inspection sign, 48-inch by 68-inch, and 3 banner signs, 2 at the top width of the garage doors, 24-inch by 96-inch and 24-inch by 108-inch, and 1 located above the office window, 24 says 24 feet. I'm sure that's 24 inches by 96 inches. These signs advertise the services available at this vehicle repair business. The property lies in a Residence C district. All is set forth in the application and plans on file with the board. My name is Jeffrey Mullen. I'll be acting as a chair. With me is Emmanuel Alves and Virginia Donahue King, members of the Board of Appeal. I have in the file a copy of the 1955 special permit. I've got, I don't have a lot else. So, let's see what I've got. Excuse me for a second. Got the 1955 special permit. I've got an application under the State Building Code for some improvements to the premises. I've got a request for a complaint, criminal complaint, sworn out by the code enforcement officer at the property. I've got a notice of probable cause hearing dated July 26, 2019, filed by the Milton Inspectional Services Board. I've got an agreement for continuances. I've got another notice of probable cause hearing. I've got a plan of the premises, and I've got a photograph indicating the proposed signs consistent with the application, although I think those are there.
They are.
I've got a letter to Mr. Edward O'Neill from the Town of Milton Inspectional Services indicating that the signs do not conform to the requirement of the permit. And I've got a request. I've got a letter from Mary McKettrick, several pages discussing the facts of the application. Now that is the extent of the file, which is on file with the board and open for public inspection. I see the applicant is here and with his counsel. How may we help you?
Well, good evening. I'm Mary McKettrick, representing Haydar Ali, who is the owner of the, who is the person who's the tenant at the site and is running the vehicle repair business there and has been for several years. Just briefly to recap the history of this property, this is a pre-existing non-conforming use well before the zoning bylaw in 1938. And in 1955, the owners applied to replace the existing building that was used to repair cars with a new building. At that time, this was not only a repair facility, but it was a gas station. And it had a Jenny gas station sign on a tall pole. I don't go back far enough in Milton to remember that, but maybe somebody here does. At the time, this was considered, or this was treated by, this was a Board of Appeals hearing. They treated it as a modification of a pre-existing non-conforming use. They allowed the new building, but they did apply certain conditions to the permit. And one was that that the applicant was to be allowed to have the freestanding Jenny gas station sign on the pole. That was an existing sign. But that if they wanted advertising signs, additional advertising signs, they would have to come back to the Board of Appeals for a special permit or an amendment to the existing special permit. There never was, that I can find by searching the Board of Appeals files, another hearing on signs for this site, except for one, which I'll tell you about in just a minute. There was a hearing, but with no conclusion and no decision 2 years later, in 1957, and it was about various complaints and concerns that neighbors had about whether the permit was being followed, whether there were some signs on the premises that needed further permission. And the Board of Appeals invited the applicant to come back with an application for the signs on the premises and discuss the fact that they would probably need some advertising signs. And some of the other questions were resolved by discussion. But there was no decision. It wasn't a Board of Appeals case that resulted in a decision that was recorded or anything like that. That's the only thing that I could find in the record, except for the fact that when Mr. Ali began his operation, he went to the building department to apply for the permanent sign that's on his building, SE and Automotive. And the procedure that he was told to follow, and which he did follow, was that he would be going to the Board of Selectmen. So the way sign applications were being handled was in flux at that time. It was 2014. That's what he did. He received permission from the Board of Selectmen for that sign. And that's why that sign is not part of this application, because it's been approved. After he opened his business was slow. And he put up these additional banner signs sometime thereafter. And it did substantially improve his business, and he seems to be doing okay now. He has enough customers. He's been operating for several years, and these signs have been up for a while. Don't know exactly how long. Mr. Ali, so recent history, however, is that in the spring, the owner of the property, the O'Neills, received an enforcement letter or a notice of violation, zoning violation, saying that there was unregistered car on the premises, that there was some junk and maybe extra tires on the premises, and that those violations needed to be removed. And that the third issue was that there were signs that had not been approved by the Board of Appeals. So after that, it's a little unclear to me exactly what the sequence of events was. Probably there was some miscommunication. Maybe notices originally going to the owner was a source of confusion. I don't know. But in any case... I can speak to that. Okay, well, you'll have an opportunity. Thank you very much. And I'm just trying to explain what happened. The owner, I think, has tried to follow through, but he got caught up in this process. In June, the building department filed a complaint that went to housing court. And so that's why in the history of this case, you'll see a housing court preliminary determination, and then you'll see that that was continued until later this October. And so it is important, and I appreciate the fact that the Board of Appeals has been willing to schedule this case now so that you can consider these other signs and whether any of them should be given permission. When Mr. Ali filed his sign application, I didn't represent him yet, and he filed an application for the signs that he has on the premises. So this picture that you have shows exactly what's there now and exactly what was these signs are the subject of the notice from the building commissioner that these signs would need to have approval or a special permit in order to be displayed. We have discussed the signs since then, and at least as to one of them, Mr. Ali is proposing that he remove the banner sign that advertises state inspections because it's a duplicate. I mean, he has a sign here, which is kind of a conventional way these state inspection facilities are advertised at gas stations, and so he doesn't necessarily need the second one. So he's proposing that I remove this sign, and he's asking whether you would authorize him to keep the other signs. They are advertising signs. They do help him tell neighbors and people who drive by what he offers at this business. It is no longer a gas station, and I think it's important to understand that in 1955, the permit required that the owner come back with permission for advertising signs. There's some acknowledgement in the discussion and the record for that hearing that the board realized that they would probably need advertising signs, but they wanted to control them, and so they required that they come back for a special permit for any advertising signs. They seem to distinguish between the Jenny sign, which I'd say is somewhat equivalent to S&E Automotive, although it would have been more intrusive, and an advertising sign. I guess you'd call it a name sign. It's the name of the business. There is no Jenny sign anymore. There is no pole. There is no gas station. So this is actually, it's a less intrusive facility than it would have been when it was both a repair facility and a gas station. That's many years ago, 1955. In other respects, I don't think it necessarily looks too different from the way it has over the years. There's always been this little office in the two-bay repair area. There isn't really room for more than that. There have been various tenants, I believe, over the years. I only remember the most recent before yours. And area residents use the repair service, and they come here for inspections. So that's the summary of what the application is about. I'd appreciate any questions, and we'd be happy to answer them.
Let me just, I'd like to hear from the woman behind. Maybe you could recognize yourself and come up and speak and let us know who you are. And I'm interested in the delay in between March 15, 2019 and today. So you were going to speak to that, ma'am?
Yeah, my name is Nancy O'Neill. I represent the O'Neill Realty Trust, which owns the property. And I just wanted to speak to the, when I received a letter from, I guess it was the building inspector, that they were going to, that something had been filed in court. I never received a letter before that. The minute I got that letter, I went up and I saw Joe Prondak. I never received a letter saying this had to be done and this had to be done and this had to be done until they said they were taking the issue to court. At that time, I did go up and I spoke to Joe, and he said, well, we will, give you time to do the things that you have to do, instead of going to court.
All right, so I'm not, I mean, I don't know, and I don't, this letter was dated March 15th, 2019. It was written to Mr. Edward O'Neill at 91 Allerton Road. Is Mr. O'Neill involved in the trust?
Mr. O'Neill has been dead since 1973.
What's the address of the trust?
The address of the trust is 91 Allerton Road.
Did you get this letter?
Never got that letter.
Okay. I'm just going to explain the record here, which is more extensive than I had thought when I first announced the file. So the letter comes in March 15th. There's a request for a criminal complaint filed by the code enforcement officer on June 4.
Correct.
There was a notice issued by the Housing Court Department in Brockton on July 29, marking this for a hearing on October 18th, 2019. There was a notice of probable cause hearing issued on July 8th, noting a hearing in the Canton session of the Housing Court on July 26th, and an agreement for continuance in this matter at the Housing Court on October 18th, 2019, signed by plaintiff's attorney and defendant's attorney. Can I ask you what happened on the 18th of October?
I didn't represent you. Did you have an attorney at that hearing?
No, we didn't have an attorney.
Well, it actually hasn't come yet.
In 2 weeks.
It's in 2 weeks. So there's a trial on this matter in October 18th.
Yeah.
So how does it get this? This feels to me like nothing would have happened if they hadn't gone to court. Is that true? You agree with that?
Yeah, I mean, I don't know what would happen, but I came to fill the application, and when I spoke with him, he told me, "Oh, you just have to do it online," and I did do it online on May 4th, I believe. And when we went to court, I showed him the receipt of me filling it online. I'm not into construction. I'm not really quite sure what the procedure was, and I filled everything in, and it says you have to wait for a response. I never heard a response until I got that letter that I have to go to court.
Yeah.
There was no denial letter issued. That's what created the problem, in my opinion.
Well, you didn't need a denial letter. This is a notice of
No, before
this is
the
an
court.
enforcement matter.
Before the court.
I don't know the procedure about the court. What I'm speaking to is the fact that this matter was called to your attention in March. Today's October 1st.
I understand, but
How long have the signs been up?
I came and I spoke.
How long have the signs been up?
I would say February. I came and I spoke with the building inspector. And I explained to him, I was like, what's going on? I mean, this is the only way for me to pay my guys and pay my rent and pay my taxes. I mean, without the sign, we were not getting any work. People did not even knew that we offer state inspection until we put that sign up there. And it helped a lot. And he's like, okay, that's fine. All you have to do is fill up for a permit. You will get denied, and then you'll go in front of the board, and they'll give you a decision. And we agreed to that, and I was like, what's the process of filling the permit? He's like, you have to go to the website, and you'll follow the instruction on the website. You fill the application, and then we'll send you a denial letter. And when you get the denial letter, then you can come. I never got the denial letter. The next letter I got was the letter for me to go to court. And then when I came with the letter here, and I spoke with him, and he's like, well, you filled the application, but you still had to attach some drawings and stuff to it. I explained to him, I was like, he told me it's pretty easy to fill out the application. I mean, I did submit it, and the application did say you have to wait for an answer from the building department.
Okay. So you put the signs up in February. Before that, there were no signs?
No, there was no.
Was there an S&E Automotive sign on the property?
Correct.
And is it your testimony that it's just these 3 signs? Is you're going to remove the middle sign? There'll be one sign in the bay on the westerly bay. There'll be one sign above the office.
It would be 2 signs on the banner, but I would remove the one on top of the office. I would move that. You see, this is state inspection in the middle.
Remove this.
Remove it and put the one on the office under the bay, so this way they look more,
Move this to here?
No, the one on the far
This
left.
to here?
So I would
The
move-
office sign
I
would be
move this
moved
and then
to the
move this
bay.
out completely, the state, and then move this one to here, just to show that we can do.
And there'll be 2 signs on Brook Road?
You mean both sides of the freestanding?
Yep.
Yes, a rolling sign with 2 sides.
There'll be no signs on the building itself?
S&E
Well,
Automotive.
just the S&E Automotive. That's the S&E Automotive, the one in the middle, up top, right here. That's staying there.
No. The signs on the posts.
Oh,
In the
this?
photo. In the photo, on the posts.
The
Oh, this one?
registration.
This is actually by the state, we have to
How many,
show.
I just want to know, how many signs are we talking about here?
So it's 1, 2, 3.
4, 5. There's one on each post, right?
Well, those were already, when we got the,
Were they there in 1955?
no, but when
Then you need a permit for them. So
did.
let's get a plan. I just want to understand, how many signs you're asking for?
all right. Do you want all the signs, or what are we going for
I
right
want
now?
all signs.
All signs, all
I'm
right.
assuming that not one of these signs is authorized, because none of them were in the 1955 permit, right?
I thought I heard there was an update.
The
S&E was there.
The Board of Selectmen approved the sign that's on the building by the procedure that was then
And those 2.
required by the building department.
Okay. What
So
did the
the
Board of Selectmen?
S&E Automotive sign is approved by a decision by the Board of Selectmen, which was at the time, but the Board of Selectmen were requiring that all sign applications go through them. We were in between revising the bylaw.
Yeah, I mean, that still is the bylaw, right?
No, the bylaw, that's only for appeals now. The Board of Selectmen only get appeals.
Well, the Board of Selectmen can issue signs in residential districts for public safety and public health purposes. That's still in there.
Well, yeah, they can, but they can't issue any other type of sign.
Yeah, what we're looking for,
Normally, it would be a variance.
yeah, but you're asking for a modification to the special permit because this is a pre-existing nonconformity and you're enlarging it.
And because it's
So the
in the
S&E
special-
Automotive sign has been approved by the Board of Selectmen.
Correct. So
How about the signs on the posts?
I was actually here when that happened, so it was this, and this post sign on this side, on the one on the other side, we must have them by the state so we could do inspection. The only way for us is basically showing, the color of the inspection, and on the other side, we have to advertise saying our hours.
Well, I appreciate that. I'm just trying to understand how many, that doesn't,
So that would be
the
one.
fact that the Commonwealth requires it doesn't give you a special permit from the Board of Appeals. That's my point.
Correct. No, but this is what I'm talking. When we came for this, we also requested those to be on, and they said that's fine.
Who said that?
The people that when we went to the
Board of Selectmen.
Board of Selectmen, correct.
The Board of Selectmen also
Same guy
authorized
did all 3 signs,
the S&E and then these 2.
and these 2, correct. Yep.
Okay, so there's 3 signs that have been authorized by the Board of Selectmen, the 2 on the pillars and the 1 in the middle.
Correct.
Okay. And what you're asking for is a sign in the west bay, the sign that says mechanic on duty to be put in the east bay.
Correct.
And 2 signs on Brook Road.
Correct. That we moved.
And there'd be no other signs on the property.
No other signs.
If you're looking at the property now, on the west side of the west bay, there's an inspection sign right here. Is that coming down? There's a sign right there.
Right now?
Yeah.
You mean around the corner?
I think it's right there. I think
It's
it
around
says
the corner.
inspection. Yeah. Is that coming down? Be no other signs on the property?
Yeah, there would be only these signs. There would be no more signs. I will bring it
So
down.
the total inventory of the signs will be the middle sign, S&E Automotive, the
Correct.
2 signs on the pillar, 2 signs, 1 sign in each bay, and 2 signs on the street.
Correct.
That's what you're asking for. Okay. Can I ask you if you're otherwise in compliance with all of the requirements of the 1955 special permit?
I believe so. I mean, we didn't really do
Where
it
do you
since I
park?
leased. Where do we park? Well, customers, when they come in, they park on the parking lot.
Where do you park?
Me personally, on the street.
The permit provides no cars shall be parked in the area in front of the proposed lubratory in the gas station or elsewhere on the premises except those which are awaiting service. Is every car on the lot awaiting service?
Most of the cars in there, they're for repairs.
It needs to be all of the cars. Are all of the cars in the lot waiting for service?
Correct.
Including the car that's on the east side in between the store and the gas station?
There's no
The car
car
there today. There's a car there right
There
now,
was a car
between the food mart and the gas station. It's got a plate on it.
I could tell you that probably last week it was not there because I have another location that I go to.
That's okay. Yeah.
But there's not supposed to be any cars there.
The only cars, just to be clear, the only cars that can be on the lot are
Yes.
those waiting service.
Correct.
Yeah.
I don't own any of those cars, if that's what you're trying. Yeah.
That's not the
just
issue.
for service.
The issue is
correct.
what they're doing there.
Right.
That's all.
If they're there, then they're definitely getting serviced.
So, the permit also requires that no bright colors whatsoever shall be used in any part of the exterior of the building. Is there any way to change the color of that sign?
The banner, yes, I can make it white and blue, like the mechanic on duty, if that's okay.
Any questions?
No.
Can I see that picture? This is removable, right? This-
Correct. We put it inside at night and we put it outside in the morning when we work.
Mrs. McGattrick, if the board were inclined to approve this, would your client be willing to accept the conditions in the original permit?
Yes, I honestly assumed that that's what we were operating under, and you're perfectly correct to be looking at the details of what's required. There appeared to be a concern at that time with a lot of congestion, with a lot of cars that were being parked on the street and all over the place. That has not been a complaint recently, or as far as I know, in the recent past, it was not the subject of the complaint that came from the building department this year. The building department complained there was one car on the premises at that time that had to be removed. It was unregistered. And there
That
was
was my plow,
there was some,
actually.
yeah.
I used to plow the property with it and we got rid of it.
he felt you
So-
could not allow that to remain all the time parked, which is what we're talking about now, whether there are any cars on the site like that. The other question was some debris and some tires, and I asked the building commissioner, the building inspector today, I also asked you, I believe that has been
Correct.
removed.
It was the tires that were on the side of the building, and the problem is there's only one company that removes tires in our part of Massachusetts, and they come once every 2 weeks. In 2 weeks, we do maybe 8 tires. We are not a busy shop. We're cutting the edge every single week, to be honest with you.
How many customers do you think you have a day?
Not enough, to be honest with you, not enough. So, the reason why I have another shop is because I sometimes funnel into the shop. Like, I got to make my payroll and everything else, and I have a shop in the city. And, luckily that shop is amazingly busy that I can, I love this location, the guys that work with me here, they've been with me for a while, and especially Mike, the older gentleman.
How many people work there?
2 guys.
And what are your hours?
From 8 to 6.
Hey, did you talk to the neighbors?
Yes, I actually spoke with a couple of the neighbors. Nobody.
Person in back on the parkway?
I don't think he owns the house. I know the tenants, they're my customers, but I didn't go knock on any person.
Is that the condominium building that's in the back on the parkway?
I know it's a 2 or 3 unit right behind me, and I know, 2 guys. I'm not sure if they live in the same place or not, but they're my customers, and I never had an issue with them.
Okay. Let me ask if there's any other questions of my... And this was advertised? This hearing was advertised?
Yes.
Okay. Let me ask if there's anybody in the audience who'd like to be heard on this matter, either in support or or in opposition. There is no such person. You ask the applicant or the owner or the counsel of the applicant if they've got anything they'd like to add.
He's just he's really an excellent tenant, and any time there's been a problem, I've gone to Ada, and, we've worked together to try and correct whatever needed to be done.
I was like really stunned when I went to court, and I even met the inspector there, and I explained to him, I was like, I'm really stunned that we're here. If he just had talked to me, told me what else I needed, to submit the application, but.
Okay.
I hope it will all work out, I guess. I'm really, I don't know what else to say.
Let me speak to you. We'll close the evidentiary hearing of the matter. Discuss this in open session. So the reason why this is a difficult case is that it's pretty rare that the town would take a business person in this town to court. And this has been marked for a hearing, which is effectively a trial, on October 18th. It's pretty drastic. And that indicates to me that the building commissioner is frustrated and the code enforcement officer is frustrated. Now, I know this property pretty well, and I've been looking at it. It's actually in better shape and overall appearance than it has been in the past, in my opinion. That's a good thing.
Do you like my rose bushes?
I see them in the photo. I can't say that I've been looking at the rose. It's a pretty busy intersection, as you know, Mrs. O'Neill. The other thing I'll say is, the reason why this is such a significant, the other reason is it's in a residential area, and you've got a gas station that existed since at least 1932, predating the zoning, that has, not unlike other commercial businesses in the town, has grown into this, and actually has grown and then shrunk, really, as to Marion's point. But you still just have the special permit, and there's some things in the special permit that don't quite fit with what's going on, and we're trying to do our best, which is why I raised the color. There is, for example, an obligation that there be a picket fence behind you. We're not here to enforce every provision of the
There is a fence behind there.
special, It says not less than 4 feet in height shall be constructed along the rear line. This to be on top of the retaining wall which exists or will be constructed
There
along
is
that
one.
line. Okay. So there's 21 conditions of this special permit. And I would urge you to become familiar with the requirements of the special permit. And the reason why I think the code enforcement officer has been so diligent is they're trying to enforce the provisions of the special permit. Now, with that said, you've got a request that has been even tailored tonight which strikes me as not unreasonable, particularly if a couple of things happen. One is we eliminate one of the signs, and you have a state inspection sign and a mechanic on duty sign above the east and the west bay. Both of them would be white.
Correct.
No bright colors, consistent with the 1955 permit. In that there be a state inspection sign on Brook Road in both directions. Although you're not really able to enter the property heading westbound, right? You have to go around?
Correct. One of the reasons is...
Yeah. No, I remember the modifications.
No, there is a way that you can enter from there.
You can?
But what happens is cars coming down Blue Hills Parkway want to avoid the light, and they come through. So in most cases, he tries to keep a car there. So kids are walking from the Tucker and everything like that. Yeah. And that's an issue.
It's a tricky situation.
Yeah, so they try and close that up. Yeah.
Because they come really fast, and sometimes we're backing from the bay.
We would, you would keep the two pillar signs, but otherwise there would be no other signs on the property at all.
Correct.
Whether they're shown in this photo or not, that's the representation. That's what we're being asked for. And you've agreed that with the exception of the pillar signs and the S&E automotive sign, all three of which have been represented to us tonight that they've been approved by the Board of Selectmen, those other signs would be brought in when you're not in operation. Is that right?
Correct.
Including the one on Brook Road. Can that come in?
This one,
That's
yes,
portable.
rolls in, yes, in and out.
So that's Manny's question. So, and these won't be visible so that you'll close the doors at night, no one will see the signage, with the exception of the signs that have been approved by the Board of
You
Selectmen.
can still see them if you close the door correctly, but I can put them inside where that's not a problem.
They'll be not on the exterior of the premises, we'll put it that
So
way.
you don't want them visible at night?
I think that's right. That's
I'm
correct.
just making, I
Yeah,
want to...
that's the point.
And I want to make, excuse me for interrupting, but I just want to be sure that I know what you're approving. The mechanic on duty
Considering,
sign...
we're deliberating right now.
Yes, I'm sorry, considering. The mechanic on duty sign would be located where the state inspection sign on the building is now.
Right.
The oil change special sign would no longer be yellow, it would be blue and white.
Yeah, that's right. I guess that's right. I thought, yeah, okay.
There won't be two inspection signs.
Okay.
Yes.
Well, there's already two on the rolling sign. There won't be two, one in the building and one in front. Right. Is that your understanding?
Yeah, so there'd be a total of 4 additional signs, 2 on the street, 2 in the building, to go along with the 3 other signs, all of which are talking about activities that are going on the premises, and most of which are really geared towards the inspection. Ginny, I give you an opportunity. So that just to get on the table, that's what we're talking about. Ginny, do you have anything you'd like to add?
Well, I think because of that funny way of approving the 3 signs by the Board of Selectmen, if we were to approve all of the signs and the additional signs, that we should include those older signs in this modification of the permit.
Acknowledge that they're there.
And perhaps more than acknowledge, but give an approval of that?
Yeah.
Because we seem to be after that law, but it was the proper law at the time, so it just seems to me a better idea for any future boards and clients and customers and everything that are sitting around this table or another one, that they can look at just one document.
Okay.
And then referencing back to 1955.
Manny?
So, the question of authority. I don't know what the bylaws provided at the time of the 1955 decision, but presumably the board had the authority to actually approve signs on residential properties. I'm assuming that's the case. It's not clear to me that that exists now, that this board has that authority. Are we proceeding under Section 4?
No, I'm saying under Chapter 48, Section 9, this is an enlargement of a pre-existing nonconformity which was authorized by a previous special permit. So put it this way, if there weren't signs on the property when the original special permit, we wouldn't have this use to be modifying, but signage is a use, or it's an accessory use to the main use. That's the way to look at it, I think. That's a procedure.
So that's Section 4 of our bylaws that allows us to expand on nonconformity. Got it.
As I talked to the building inspector about that, that was his view as well, because the sign bylaw obviously doesn't apply.
Right.
Yeah.
Nope.
In fact, prohibits it, yeah.
I mean, the special permit from 1955 specifically authorizes an application for a special permit for additional signs.
Yeah.
So my view was that this all came under, which is why I think your comment is apropos, all sign applications at this site come under the 1955 special permit, which is still in effect, because the business has been continuously operated since 1955. And so it's unlike other commercial properties in residential zones where I've had to come in with an applicant and ask for variance because we don't allow signs in residential zones. But this one is somewhat unique because the original 1955 special permit, which was under Section 4 and as a modification of a pre-existing nonconforming use, did allow a further application for advertising signs. But that was just my view. Whatever the board decides is fine.
Do you have anything you want to say about the merits of the application as Ginny and I have laid it out, Manny?
Again, I asked that question because I was trying to think the standard would be applying in reviewing this request. And I think if the standard, as I understand it, is that this is not substantially increasing any detrimental or injurious effect on the building or the neighborhood, I agree, and I think I'd be inclined to approve the application. So that's where I'm leaning.
Okay. So why don't we put it to the vote? So we're going to consider this application with the two signs on Brook Road, the sign in each of the east and west bay, both white, one indicating mechanic on duty, the other indicating oil change. 3 other signs being permitted by the Board of Select, or the Select Board, but also authorized by the Board of Appeals under the 55 permit, but no other signs on the premises. And all of the signs, except for the signs approved by the Board of Selectmen, would be not visible when the premises is closed. I think it's also important that the permit reiterate the fact that the applicant needs to comply in every respect with the, otherwise, unless it's modified with the 1955 permit, specifically concerned about parking, although I did speak to the building inspector about that, and he indicated that all of the cars there are awaiting service. I mean, that's the rule. In fact, given the parking shortage on Brook Road and the fact that you, as the operator, park on Brook Road, that may actually not be a good result, but that is what the permit requires. It may not be the most optimal situation, but it is what it is, and I would urge you to take a look at all those cars, that's specifically the car between the Food Mart and the garage, which is a plated vehicle, but it doesn't look like it's waiting for, it might be waiting for service, I don't know. If they're waiting for service, they can be there. Within a reasonable, I'm sure there's some reasonable standard, they can't be waiting for service too long. And, you know, we give due respect to the folks who wrote this permit. I guess it'd be 64 years ago.
Reading the transcript, there was a considerable concern at the time with the idea that the gas station was going to allow, or was allowing, people to park cars and commute to Boston.
Yeah, sure.
In other words, use it as a parking lot.
Yep.
And that, I think, is where the condition comes from.
Yeah, I can see that. It seemed to me in the more recent past, there were cars there that frankly weren't waiting for service, and I think that may have precipitated all of this. I would urge you to not find yourself in that situation again. I think if you were back in front of the Board of Appeals in a relatively short period of time, faced with the same facts, we might not be as sympathetic to the situation. But I think on balance, a commercial business needs signage. A fair reading of the 55 permit, there is signage permitted, and in fact, the permit permits the board, as the applicant's counsel has said, to further modify the permit. But as requested, it doesn't seem to me to be more detrimental than the current use of the premises is, which, you know, has an impact on the residential character of the neighborhood, but no one's having been notified, no one is in opposition. It seems like a reasonable application, so I'd vote, with those conditions, I'd vote to support the application as presented and modified at this hearing. All in favor?
Aye.
Aye.
Okay, so you've got your special permit. I'd urge you to, a special permit application, I'd urge you to make sure that the folks who are involved in the court proceeding on October 18th know about this, because that will be important to that. And Mrs. Sutton, maybe I could ask you to let the code enforcement officer of the town of Milton and the building inspector know about the action of the board tonight. And in a reasonable time, we'll get you out or I guess perhaps you, Mrs. O'Neill, the notice of this, or perhaps you are the applicant, although the enforcement went to you or to.
He's the applicant, has a property interest, but I think the owner, I've always liked to do both. So.
We also make a note to correct the name of the trust, so that the mix-up with the notification doesn't happen again, and Mrs. O'Neill can get her mail.
I did get the second notice. I never got the one on March 15th. What I did get was the one that said, no, it was going to court.
I believe that was in June.
That was the June one I did get.
Okay.
I never got the March one. And that's when I went up and I talked to Mr. Prondak.
Okay. Well, we'll take steps to see if that doesn't happen again. Or
We should probably change the ownership, the name. Yeah.
Okay. We're adjourned.
Thank you very much.